All right, let's jump right into it. Welcome to the Explainer. Today we're building your ultimate A-level law survival guide for mastering the Occupiers Liability Act 1984. Now, if you've ever stared at these statutory provisions and thought, how on earth do I actually apply this in an exam? Well, you're in the right place. We're going to break this down logically, visually, and efficiently so you can completely nail it. Here's our game plan. We'll start with the shift from common law to statute. Then we hit the three-part gate test, which is basically the core of your exam strategy. We'll unpack Tomlinson and public policy, run through some rapid-fire supporting cases, talk defenses, warnings, and remedies, and finally, we'll wrap it all up so you can ace your A-level exam. Let's get moving.
Section 1. From common law to statute. Because before we even touch the 1984 Act, we've got to know exactly who we're dealing with.
So it really comes down to this one fundamental question. Do occupiers actually owe a duty to people who literally shouldn't even be on their land? Historically, under the old, pretty harsh common law, the answer was basically no. Unless the occupier deliberately or recklessly hurt them, trespassers were on their own. But things evolved. Under today's 1984 Act, the answer is yes. But, and this is a big but, with some incredibly strict limits. We're talking way narrower than the duty owed to a lawful visitor.
So what exactly is a trespasser? It's simply an entrant with zero permission or authority to be there. But here's an absolutely crucial tip for your problem questions. A completely lawful visitor can actually turn into a trespasser if they exceed their permission. If someone wanders into a room with a giant staff-only sign, boom, the rules instantly switch from the 1957 Act over to the 1984 Act. Keep an eye out for that trick.
All right, moving to Section 2. The three-part gate test under Section 1, subsection 3.
To prove that a duty of care is even owed in the first place, your trespasser claimant has to pass through three literal gates. Gate 1, the occupier must know about the danger. Gate 2, they must know or have reasonable grounds to believe a trespasser is in the vicinity. And Gate 3, the risk must be one where reasonable protection should be offered. Think of it like a strict security checkpoint. If even one of these gates stays locked, the claim dies on the spot. No duty, period.
And this brings us to a massive point. Check out this exam gold tip straight from the 2-2 materials. When you're writing your essay, the vast majority of your analysis should be spent right here, discussing duty and breach. Don't rush this. You really have to apply every single element of that gate test to the specific facts of your scenario.
Let's see Gate 1 in action with the classic case, Rhind versus Astbury Water Park. Here, a guy totally ignored a strictly no swimming sign and jumped into a lake to grab a football. Tragically, he suffered serious injuries when he hit a fiberglass container that was resting completely hidden at the bottom.
Now, look at the legal outcome for Section 1, subsection 3A. Remember, the occupier has to actually know or have reasonable grounds to believe the danger exists. In this case, the container was totally invisible from the surface. It was only found later during an underwater inspection. Because the park owners genuinely had no clue it was down there, Gate 1 slammed shut. No duty was owed.
Okay, how about Gate 2, the vicinity test? We look at Higgs versus Foster for this one. So, a police officer was doing surveillance at night and climbed a wall into a coachyard. He wasn't using a torch, and he ended up falling into an uncovered inspection pit. He suffered severe injuries that actually forced him to retire. So, the occupiers knew the pit was a danger. That means they passed Gate 1. But they had absolutely zero expectation that anyone, let alone a police officer in the middle of the night, would be trespassing in their private yard. Since they had no reason to suspect a trespasser was anywhere near that danger, they completely failed the vicinity test of Section 1, subsection 3B. Gate 2 stays shut, and the claim fails.
Let's head into Section 3, Tomlinson and Public Policy, which tackles Gate 3.
You absolutely have to know Tomlinson versus Congleton Borough Council. The facts are pretty heartbreaking. An 18-year-old goes to a council-owned country park, ignores prominent signs warning of dangerous water and saying no swimming, and dives into a shallow lake. He hit his head on the sandy bottom and was left paralyzed. The Court of Appeal originally awarded compensation, but the House of Lords aggressively overturned it, and examiners absolutely love it when you detail their three main reasons. First, the beach itself was perfectly safe. The danger actually came from his action of diving, not the state of the premises. Second, they hit hard on personal responsibility. Adults have to take responsibility for freely chosen obvious risks. And third, public policy. They argued it's just unreasonable to force a council to drain scarce public funds to destroy the social utility of a beautiful park, all to protect people from their own foolish choices.
All right, Section 4, rapid-fire supporting cases. You've got the 3 main gates locked down. Let's load up your arsenal with a few more cases to really beef up your exam answers.
Let's start with a little historical context. BRB versus Herrington from 1972. A 6-year-old boy was badly burnt while trespassing on an electrified railway line. The fencing was completely vandalized, and the rail board actually knew about it. The House of Lords stepped in, used the practice statement to ditch the harsh old common law, and established a duty of common humanity. This was the literal catalyst for the 1984 Act.
When you're dealing with obvious dangers for adults, contrast these two. In Ratcliffe versus McConnell, a 19-year-old snuck into his college pool at night and dived into the shallow end. The court said, look, there is no duty to warn adults about super obvious dangers like a pool's depth. Contrast that with Donoghue versus Folkestone Properties, where a guy decided to dive off a harbor slipway at midnight in the dead of winter. The court ruled that an occupier doesn't owe a duty if the trespass happens at a totally unforeseeable time of day or year.
Now, what if the trespasser is a child? Well, the statutory rules don't actually change. In Keown, an 11-year-old boy climbed up the outside of a hospital fire escape to show off and fell. The court found the fire escape wasn't broken. The danger was entirely in the kid's behavior. And in Baldacchino, a 14-year-old dived off a navigational beacon. The court basically said even for a 14-year-old, diving into unknown waters is a blatantly obvious risk, no duty.
Let's look at Section 5, defenses, warnings, and remedies. Once you establish duty and breach, you need to stick the landing on your problem question.
Let's blitz through these. Under Section 1, subsection 5, a warning sign can clear the whole duty, as long as it explicitly identifies the risk. We saw this in Westwood versus Post Office, where an authorized personnel-only sign was enough to protect against an adult who snuck into a restricted motorroom. Next, Section 1, subsection 6 covers consent, or valenti. If the trespasser fully gets the nature of the risk and goes for it anyway, that's a complete defense. If that fails, you can always argue contributory negligence to partial down the damages. And finally, the massive catch. Under the 1984 Act, trespassers can only get remedies for personal injury. They can't get a single dime for property damage, so forget about claiming for a smashed phone or ripped jeans.
Finally, Section 6, how to ace your A-level exam. Let's pull all this theory into a super clean step-by-step game plan. When you're sitting in that exam hall, I want you to structure your answer exactly like this. Step 1, clearly identify that the claimant is a trespasser or a visitor who pushed past their permission. Step 2, methodically apply the Section 1, subsection 3 gate test, check danger, vicinity, and reasonable protection. Don't skip a single one. Step 3, briefly note Section 1, subsection 4, mentioning the standard of care is objective. Step 4, slam down any relevant defenses like warnings or contributory negligence. And Step 5, wrap it up by explicitly stating remedies cover personal injury only. Stick to that framework and you are hunting for top marks. I'll leave you with this to chew on, especially for those of you gunning for those top-tier essay grades. Does the really strict approach in cases like Tomlinson hit the perfect balance between personal responsibility and occupier liability? Or by setting the gates so incredibly high, does the 1984 Act actually leave vulnerable trespassers out in the cold? Have a critical think about the public policy pull here. It's great stuff to debate. Thanks for hanging out with me for this explainer. Until next time, stay focused and keep up the great work.